In this lecture, we are going to discuss the important topics of company law subject. It means the most likely questions which can be asked in the exams we are going to discuss one by one. First, we will see the list of chapters. There are total 34 chapters, and out of these chapters, there are few important chapters from which the question is bound to come. So, first of those chapters is types of companies, chapter number 2. After that, there are chapters, that is chapter number 14 to 18, 21 and 23. These are institution of director, independent director, board and its powers, appointment and remuneration of key managerial persons, general meeting, accounts and audit, and the board's report and its disclosure. These are the important chapters among total 34 chapters. Now we will see each chapter one by one. First, let's look at the chapter number 1, that is Introduction to Company Law. The first topic which is important is the nature and characteristics of companies. The first 4 characteristics are very important. After that, distinction between company and partnership, distinction between company and HUF, distinction between company and LLP. The most important question of this chapter is doctrine of lifting or piercing the corporate will. You cannot afford to ignore this. And their judicial pronouncements, that is the decisions given by the court on this topic, is very important. You have to quote those. And the last thing in this chapter which is important is the illegal association. Now let's move to chapter number 2, that is types of companies. In types of companies, the definition of private company is important. After that, one person company is important, then small company, then association, not for profit, government company, and then subsidiary and associate companies, and lastly the dormant company. These are the important items of this chapter number 2. Now let's move to the chapter number 3, that is the promotion and incorporation of companies. The first important question in this chapter is the definition of promoter itself. Definition is given under the New Companies Act, as well as the SEBI regulation has defined the term promoter. Then the promoter's contract and the ratification thereof. You have to quote this also. Conclusive evidence. The certificate of incorporation is a conclusive evidence. This question can also come up. Punishment for furnishing the false and incorrect information at the time of incorporation, and the power of tribunal in this regard. The incorporation of one person company can be asked separately. Then the incorporation of a company with a charitable object under section 8, that is association not for profit, the incorporation method. So these were the important topics of chapter number 3. Now we can move to chapter number 4, that is a memorandum of association and the article of association. First of all, the definition of memorandum of association, along with it contents what the clauses are there, so you have to remember these. Then the most important question of this chapter is doctrine of ultra wires. Apart from this, there are 2 important items, that is implied powers. That is, even if those powers are not mentioned in memorandum, management can exercise those powers. And powers which are not implied means specific mention of those powers should be there in the memorandum, then only it can be exercised by the management. Then alteration of name clause is important. Alteration of registered office is very important. There are 4 situations of alteration which you should know. After that, alteration of object clause of the company. And then the most important item of this chapter is the new item, that is entrenchment provision. After that, the provisions regarding expulsion of member can be asked, distinction between memorandum and articles, and then the most important doctrine, that is the doctrine of constructive notice of memorandum and articles. After that, doctrine of indoor management along with its exceptions. And then lastly, a small question which can be asked, the doctrine of alter ego. Now let's move to the chapter number 5, that is contract and conversion. In contract and conversion, two things are very important: pre-incorporation contracts and provisional contracts. You should know the meaning of these two. Apart from this, you should know when a company is entitled to commence its business. Apart from this, common seal, they can ask the question. And then conversion of private company into public company or a vice versa. After that, conversion of section 8 company into a company of any other kind. This is the most important question of this chapter. Then conversion of one person company into public company or a private company. And second is conversion of private company into one person company. These are the important topics of this chapter. Now let's see the chapter number 6, that is concept of capital and financing of companies. In this, first you should know the kinds of share. There are two kinds of share: preference and equity. And equity are further divided with a differential right and without differential right. And then preference shares compared with equity, the comparison between these two. And then equity, the issue of sweat equity shares. Then further issue of share, that is the right shares. After that, bonus shares, employee stock option scheme. And lastly, the issue of shares on preferential basis. These are the important topics. Now let's move to chapter number 7, that is alteration of share capital. The first two topics of this are very important, that is alteration of share capital. The ways in which share capital can be altered, this is important. And when share capital stands automatically increase as per the order of government, this is also equally important. Then a general question can be asked, like distinction between shares and stock. And then the reduction provision, that is reduction of share capital under the Companies Act, New Companies Act 2013, which have not been notified. These reductions provisions have not been notified under section 66, so they can ask from the old Companies Act. So reduction of share capital under old Companies Act 1956 under section 100, you can refer. These chances are very less of asking these old provisions, but still you have to remember reduction of share capital without the sanction of the court. And then the last question is the buyback of securities and the provisions under the New Companies Act of in this regard. Now let's move to chapter number 8, that is private placement and the prospectus. First important thing is the meaning and definition of prospectus, and then what do you mean by the term invitation to public. Then the private placement, definition of private placement, the provisions of private placement, then deemed prospectus, and the matters to be stated in the prospectus. Apart from this, offer of sale by members, this is also important. Then the most important points of items of this chapter is shelf prospectus, a red herring prospectus, a breach prospectus, and the golden rule or the golden legacy. That means everything whatever is stated in the prospectus must be true and true only. Now let's move to chapter number 9, that is the debt capital. In debt capital, you should know what do you mean by the term borrowing and power of company to borrow. And then the important question is unauthorized or ultra vires borrowing, what will be the consequences of that. Then intra vires borrowing but outside the scope of agent's authority. And then the charge on uncalled capitals, kinds of debentures, and then the difference between debentures and shares, it can be asked. And lastly, the debenture trustee. These are the important provisions of this chapter. Now let's move to chapter number 10, that is the creation and registration of charges. In this, you should know the definition of charge. It means what do you mean by the term charge, then the kinds of charges, and then the crystallization of floating charge and the postponement of floating charge. These two are very important items of this chapter. Then the difference between mortgage and charge, then registration of charge, how charge should be registered with the ROC, and the condonation of delay in filing of the charge. After that, lastly, they can ask about the satisfaction of the charge. Now let's move to chapter number 11, that is allotment of securities and issue of certificates. First thing is you have to remember is general principle regarding the allotment. After that, provisions relating to allotment under the New Companies Act 2013, issue of certificate, and then the personation of the shareholder, then requisites of a valid call, the quantum and the interval between two calls, and the forfeiture of shares, and lastly the surrender of shares. These are the important items of this chapter. Now let's move to chapter number 12, that is membership in a company. First thing, they can ask the difference between the member and shareholder. Then after that, modes of acquiring membership, these can be asked, and you should remember what is the minimum number of members required for different kinds of companies. Then expulsion of member, whether company can expel the member from membership, this is also important. And then the foreign register of members, and the most important in this, what I feel, is the closing of register of member, when a register of member can be closed, and the power of central government to investigate into the ownership of shares. Apart from this, there are one important, that is the rights of members or voting rights of members, especially the voting rights of preference shares or holders should also be remembered. Then variation of members' right, they can ask this question also. Now let's move to chapter number 13, that is transfer and transmission of security. First thing you should know is the transferability provisions under the New Companies Act 2013, and the most important here is power to refuse registration of transfer and the appeal against such refusal. Then rectification of register of members, then delegation of power to transfer. These are exercised normally by the board of director, but it can be delegated to committee. Distinction between transfer and transmission, and the blank transfer. These are the important topics of this chapter. Now let's move to chapter number 14, that is institution of directors. This is the most important chapter of company law, and there is hardly anything which is not important. So everything is important, like minimum maximum number of director, number of directorship, then appointment of director, director identification number, that is DIN, then disqualification for appointment of directors, even duties can be asked, the vacation of office of director, resignation of directors, and removal of directors. All these are important in this chapter. Now let's move to chapter number 15, that is independent director. Remember, independent director was not defined under the old Companies Act, but now it has been defined. Earlier, the provisions of independent directors were only there under the SEBI regulations, especially under clause 49 of the listing agreement. Now these are the things which they can ask in the exam: the number of independent director, qualification, manner of selection, the code for independent director, tenure and liability of independent director, even the remuneration of independent director can be asked, and lastly a comparative study between the clause 49 of stock exchange, listing agreement of stock exchange, and the Companies Act 2013 they can ask. Now we are moving to chapter number 16, that is the board and its powers. Everything in this chapter is important. You should not leave anything. So I'm not going into the details of this chapter because you cannot skip this chapter. After that, we are moving to chapter number 17, that is the appointment and remuneration of key managerial personnel. Again, this chapter is very important. You should not leave anything from this chapter. Let's move to another chapter, that is chapter number 18, general meeting. This is also an important chapter, and there are so many important things in this important chapter. Let's discuss these. The annual general meeting, you should know the provisions. Extraordinary general meeting, then the notice of meeting, and notice through electronic mode. This can also be asked in the exams. And then quorum of meeting and the chairman of meeting, the proxies, and then the demand for a poll. Who can demand for a poll? Then the postal ballot. This is also important. Ordinary and special resolution, the meaning of these two, and the resolution requiring special notice, and the resolutions and agreement need to be filed with the registrar of companies. Now let's move to chapter number 19, that is loans and investment by companies. In this, so one important question, that the loan and investment by companies under section 186, that is the provisions of this section you should remember. Then let's move to another chapter, chapter number 20, deposits. Very strict provisions have been made for deposits from the public, and there are important things about that. Is prohibition on acceptance of deposits from public, and there are rules, and rule number 4, forms and particulars of advertisement and circulars. Then rule number 5, deposit insurance, and rule number 6, creation of security. After that, rule number 13, maintenance of liquid asset and creation of deposit repayment reserve account. This is most important in this chapter, rule number 13. And then rule number 16, return of deposit to be filed with the registrar. And lastly, rule number 17, that is the penal rate of interest. Now let's move to chapter number 21, that is accounts and audit. This is the one of the most important chapters. So many things are important in this, that is the accounts of companies, requirement of keeping books of account, where it will be kept, that is the place of keeping the books of accounts, and the books of account in respect of branch office, inspection by directors of these books of account, period for which books to be preserved. After that, National Financial Reporting Authority. Then section 135, the you can say the most important of this chapter, you can say that corporate social responsibility. This is also important, recent development in company law. Then section 138, internal audit. 148, maintenance of costing and stock records. This is also important. Eligibility and qualification of auditor, very very important item of this chapter. Disqualification of auditor and the terms of auditor, all these three are very very important from this chapter. Then reappointment of retiring auditor, rotation of auditor, casual vacancy in the office of auditor, removal of auditor, resignation of auditor, remuneration of auditor, auditor's right to attend the general meeting, the branch audit, and the cost records and the audit of these cost records. All these are very very important items of this chapter. Let's move to chapter number 22 now, that is divisible profits and dividend. First you have to understand the meaning of dividend, then types of dividend, then the sources for declaration of dividend, then transfer to investor education and protection fund, and the utilization of these funds. Now let's move to chapter number 23, that is the board's report and its disclosure. This is one of the most important chapters of company law. So there are so many things which are important, like disclosures under section 134 of the Companies Act. So it means the disclosure in the board of directors report as per the act, then disclosures under various rules made under the Companies Act, then signing and dating of board report, liability for misstatement, anything is written wrong, what will be the liability, and the disclosure under the listing agreement of the stock exchange. Now look at the chapter number 24, that is the register, forms and returns. First, statutory books and register, you should know these. Register of member, this is the most important item of this. Then closure of register of member and the books of account. These are the important topics of chapter 24. Let's move to chapter number 25, that is inspection and the investigation. In this chapter, inspection, you should know the provisions of inspection of accounts, when it can be inspected. Then the provisions of investigation, this is another item, and the kinds of investigation, this is related to that. So you should know these things in this chapter. Now let's move to chapter number 26, that is majority rule and the minority rights. So the basic fundamental question is the shareholders democracy. This can be asked, the majority powers and minority rights. The principle of non-interference, that is the famous case law of Foss versus Harbatel. the decision given by the court. This is very, very important in this chapter. The exceptions also, exception to this rule which was declared, propounded under Foss versus Harbotel case, and prevention of operation and mismanagement. This is another question which can be asked. And then meaning of the term operation. This is also very important question. And the prevention of mismanagement. What are the provisions for preventing the mismanagement? Now let's move to chapter number 27, that is merger, demerger, amalgamation, compromise and arrangements. See, these provisions as per the New Companies Act have not been yet notified. So old provisions of the old Companies Act will be applicable now for this exam. So you can refer those provisions which are given under section 391 of 1956. That is the Companies Act 1956. Then the basic things you must know: the concept of merger, amalgamation, when court do not sanction the scheme. This is one of the important questions in this. Then special power of central government to order amalgamation, and the cross-border merger they can ask, because these are the new provisions as per the New Companies Act, although still not notified, but these are important. Then let's move to producer company, that is chapter number 28, producer company. See, provisions of Companies Act 1956 related to producer companies still very much active, and there will be a special act soon. It will be passed by the parliament specifically for producer company. As far as exam point of view is concerned, very less chances are there they can ask question from this. Still you have to remember the meaning of producer company and the objects of producer company. Then let's move to next chapter, that is chapter number 29, that is the limited liability partnership. In this chapter, two things are important. First is the distinction between LLP and partnership, and the second important thing which can be asked, the incorporation of limited liability partnership, that is the procedure for incorporating the LLP. However, the distinction between LLP and company you have already studied in types of companies, so again you can cover here also. Now let's move to chapter number 30, that is application of company law to different sectors. नॉर्मली इसमें से क्वेश्चन आने के चांसेस बहुत ही कम है. इसके बाद नेक्स्ट चैप्टर इज चैप्टर नंबर 31, ऑफेंस, पेनल्टीज एंड देयर कंपाउंडिंग. इसमें मोस्ट इंपॉर्टेंट क्वेश्चन जो बनता है, दैट इज द कंपाउंडिंग ऑफ ऑफेंस, द मीनिंग ऑफ द टर्म compounding of offense, establishment of special courts. These are new provisions, so you have to keep in these in mind. So, offense to be non-cognizable, these are also important. Then the list of offense compoundable in nature. These are the important points of this chapter. Now let's move to chapter number 32, that is winding up of companies. This is a little bit important. So the modes of winding. First you should know the meaning of winding up. Then the winding up by the court, what are the provisions? And the most important of this is the ground on which a company may be wound up by the court. Who may file the petition for winding up? And after that, the kinds of voluntary winding up, and in kinds, the members voluntary winding up and creditors voluntary winding up. After that, the modes of winding up under the New Companies Act 2013. These are the important topics of this chapter. Let's move to another chapter, that is chapter number 33, that is the striking off the name of the companies. First, know the meaning of the term striking off. Then after that, fast track exit mode scheme launched by the Ministry of Corporate Affairs. You should know that. Then the restoration of company's name. Then the provision relating to dormant companies in this regard. You should know all these. And lastly, let's move to the chapter number 34. That is the introduction to e-governance and the XBRL. So it is the last chapter. There are only few things which you can think of in the exams, that is digital signature certificate, then corporate identity number, and Apart from that, the e-stamp they can ask this time, and the XBRL, that is a language of communication of financial information. So XBRL, you should know the meaning of this XBRL and the benefit of XBRL. It can be asked in the exams. Now we have reached the end of our review of important questions of company law. If you want further details on this, you can see my another lecture on that, where briefly I have described all the important provisions. And if you have still any doubt, you can call it this number and try to go through all these important provisions before going into the exam hall.